Can I take you back to the question of what would happen if, let's say, an elected district attorney brings a criminal case against a foreign state or against a component of a foreign state or against a corporation that is set up and owned and controlled by the foreign state? What would happen then?
Okay, Your Honor. I mean, putting aside that that could happen with foreign officials already under this court's law, and we would be in the exact same spot. But
all right, let's say it's against a foreign state. So it's
so say
it's the
say
people
we're
against whatever.
If again, Your Honor, if they brought a criminal action that said like Commonwealth of Virginia against the Kingdom of Sylvania,
Yeah.
I think there we might well file a suggestion of common law immunity.
All right, and so the court receives that, and the court says, well, fine, that's your opinion, but we don't agree. Then what?
Well, Your Honor, that's subject to review in this court, just the same way.
After there's been a trial and an appeal through the state courts until there's a final decision from the Supreme Court of the state, then it could come here?
Well, Your Honor, presumably there are some emergency procedures there. Again, you're presupposing that if the FSIA or something like that did apply, that they'd be in safer circumstances. There might be circumstances, I was suggesting earlier, where there is some dispute as to whether, I mean, as apparently there is here, although I don't think there should be, as to whether something actually is an instrumentality of a foreign state or equivalent to the state. The state trial court could refuse to recognize that separateness and just say, you know, batten down the hatches, we're going to trial, and whatever emergency relief would be available, ultimately culminating in this court, that would be available there, would be perfectly available in these circumstances, and this court usually trusts state courts to get these things right.
Under what theory would this state prosecution be preempted by federal law? The Supremacy Clause applies to the Constitution and the laws of the United States. So what is the law of the United States that would block this state prosecution?
Well, Your Honor, I think we'd have a number of options. I mean, if the court were unprepared to accept some kind of letter from the executive stating that this is contrary
we had that.
President's foreign affairs determination.
Yeah, we had that. I'm blanking on the name of the case, but we had exactly that. President Bush sent a letter and said, quit, and Texas said, well, thanks for your opinion, but we're going ahead.
I don't want to argue against myself. I think you're thinking of Medellin, Your Honor.
Yeah, Medellin, right.
But even if that were not enough, there are a number of other actions the federal government could take up to and including, for example, entering into an executive agreement of the sort in Garamendi that would contemplate dismissal of the prosecution, which would clearly be preemptive.
When I have my...
Justice Thomas? There you go.
All right, so...
Welcome back. Thank you.
This does seem to me to get into a very interesting question that has ramifications beyond this case. So what is would you say that that it is a principle of customary international law that would bind the states under the Supremacy Clause?
Well, Your Honor, first of all, let me just reiterate what you just said, which is this is well beyond this case. The court doesn't need to decide it. There are no historical precedents for this. Therefore, under Samantar, was not a problem Congress was particularly concerned with, and we can worry about it when and if it comes up. If it were to come up, I think we would say that the Supremacy Clause and just the structure of the Constitution overall, as this court has repeatedly recognized, vests the federal government with exclusive foreign affairs powers. The foreign affairs powers are principally exercised through the executive branch, and if the executive branch has a number of tools for ensuring that the states don't start making side treaties or do things that the federal government does not approve of. And I think there'd be a number of tools that could be used here. I've suggested a couple of them. Another one of them.
Well, I just want to know the status of this rule that's being imposed on the states. So it's an inference from the Constitution. I can understand that. That's what you want us to say. It is an inference from the Constitution that the president can direct that foreign states be sued, but a state can't do that. I understand that. but when you talk about common law, then I'm more confused. Well, I'm not confused. I'm worried, because isn't it a very important question whether customary international law is binding on the states under the Supremacy Clause?
Well, Your Honor, I think the court suggested in Samantar that courts should give weight to suggest, I suppose those were federal courts under the FSIA, but the court suggested that for foreign officials, courts ought to give some respect, potentially conclusive respect, to the views of the executive branch, which would, and to the extent that those reflect customary international law, I think that might well be binding on the states, particularly because the states don't have any authority to legislate or take action that would be contrary to customary international law. I mean, I think Medellin might be somewhat instructive here, but I think it's just a more general principle that states should not be taking actions that get the U.S. into foreign hot policy water. And I think if that ever were to happen, and for some reason no sense prevailed in the state courts, this court would be able to resolve that problem. But it has never happened, which again under Samantar is something that suggests that it was not something Congress was concerned with in the FSIA. It clearly doesn't bear on the threshold 3231 question, and it doesn't have any purchase here,
Well, it's
where
true,
it's
it's
the
never
federal.
happened, but nothing like this has happened either.
Your Honor, that's not true. We've been doing this for decades. Admittedly, it's since the 80s. I'm not going to claim that we've been doing this for 7,000 years, or claim that we've been doing this since the founding, because we haven't. But that's because of a rise of government-owned corporations concealing some very serious crimes. If you look at a couple of our recent prosecutions, the Pangong one I referred to earlier is a Chinese-owned corporation that is engaging in economic espionage. We have another one against Chinese-owned corporation that involves nuclear information. And it's the considered judgment of the executive that in rare cases it is appropriate to bring criminal actions.